What's the difference between a will and a living trust? Let's talk about it. I'm Vaughn Stewart. I'm an attorney at Paré Associates here in Germantown, Maryland. Most people think that the biggest estate planning mistake they can make is dying without a will. But for a lot of families, an even bigger mistake is dying with only a will. For many people, creating both a will and a living trust makes a lot of sense. Number one, you can save your loved ones time and money. Number two, you can protect yourself from elder abuse. Number three, you can protect your own privacy. And in a lot of cases, number four, if you're in a special situation, a living trust goes from being really nice to have to borderline a necessity. So what is a will? A will is simply a written document that says who gets your stuff when you die, when they get that stuff, and which person is responsible for making sure those people get that stuff. It's important to at least create a will. Without a will, you die intestate, and your state's default rules apply to who gets your stuff. For some people, this may not be any big deal because the state's default rules is what they would want anyway. However, for other people, the default rules are not consistent with their wishes. So for example, if you pass away with a surviving spouse, your parents are still alive, and you have no children, your spouse does not inherit your entire estate unless you've been married 5 years. That's inconsistent with what a lot of people would want, but here in Maryland, that's the rule. The instructions in your will are not really instructions to any people in general. They're actually instructions for the probate court. When you die, many of your assets will be what's called probate assets, which means in order for your heirs to get the stuff that you want them to get, they're going to have to file a petition in court. They're going to have to pay court costs. They're often going to have to pay attorney's fees. This probate process is expensive, and it can be really time consuming. Depending on what state you're in or the size of your estate, this process can last at least weeks, oftentimes months, and sometimes even longer than a year. Probate is something that if you can't avoid it, you're gonna wanna avoid. So what's a living trust? A living trust is also just a written document that states who gets your stuff, when they get that stuff, and who is responsible for making sure all those people get that stuff. After creating the trust, the owners of the trust, also sometimes called the grantors, transfer all of their assets to the trust, which is a new legal entity. Because they're signing this document while they're still alive, upon their death, there are no more assets in their own names to be probated by the court. Instead, these assets pass immediately to the beneficiaries named in their living trust. A trust-centered estate plan also includes a will, oftentimes what's called a pour-over will, which states that any assets that you neglected to transfer to your living trust while you were alive pour over to the trust upon your death. And so the main difference between a will and a living trust is that wills have to go through the costly and time-intensive probate court process, and living trusts don't. If you pass away and you have a living trust, the trustee, literally the day after you die, can start distributing the assets to the beneficiaries you named in the living trust, which means that your loved ones don't have to go through all of the months, all of the waiting, sometimes all the acrimony, and all the expense that comes with the probate court process. Fear not. While the grantor is still alive, they have full access and rights to their assets. They may be in the trust name, but otherwise nothing changes. A living trust is a death planning exercise. It's meant to make your loved ones' lives easier when you die without unnecessarily complicating things while you're alive. We've already talked about that avoiding probate is the number one reason you might want to set up a living trust. Probate is costly, it's time intensive, you want to avoid it if you can, and that's the number one reason people set up living trust. But there are a couple other benefits too. The first additional reason is that a trust helps eliminate the need for a costly guardianship or a conservatorship process. What this means is, as you get more advanced in age, it may be harder and harder for you to take care of your financial affairs. Without a living trust or without something called a durable power of attorney, your loved ones would have to go to court and petition for there to be a court-supervised guardian and conservator over your affairs. This is a mess. It involves your loved ones having to essentially testify against you, coming up with all the reasons that they think that you're slipping, and in some cases, you would want to defend yourself and say, actually, no, they're wrong. This costs a lot of money in attorney's fees, it's complicated, and it can genuinely be humiliating for both the person who's getting up in age and their loved ones. And it can all be avoided with a living trust. In the living trust, you can state plainly what it means to be incapacitated, how your loved ones can verify your incapacitation, usually with, for example, the opinion of a couple of doctors. And you can name explicitly who you want to take over your financial affairs when you become incapacitated. This obviates the need for a court-supervised guardianship or a conservatorship process, which is an additional hurdle that costs money and takes time. The other nice thing about having a living trust for this reason is it protects you against potential elder abuse. People have a much harder time taking advantage of seniors who have living trusts because it states plainly who is responsible for their financial affairs when they become less and less able to take care of themselves. The second additional non-probate benefit for a living trust is simply privacy. Now, not all families care about privacy, but for some, they don't want all of their issues and the size of their estate and all their beneficiaries out in the public record. And I get that. It's important to know that a will is a public record. Anybody can go down to the courthouse in Maryland or really any other jurisdiction and pull up your will. A living trust is private. The only people that'll know the contents are the beneficiaries and the trustees. Now, when does a living trust go from being nice to have to downright necessary to have? For a lot of folks, a trust is simply a way to avoid probate. It saves time, it saves money. For other folks, maybe if you have a really small estate, or maybe all of your assets are things like joint ownership of a home or beneficiary designation on a retirement account, those assets would pass directly to your heirs upon your death and avoid probate. So for those folks that have no probate assets, maybe you don't need a living trust. If you have assets that are going to be probate assets, that would be one reason you would definitely want a living trust. But for other types of families that we talk to here at my law firm, a living trust is downright necessary. So let's talk about those situations. First, a living trust is critical if you have minor children. If you die without a trust, whether you have a will or not, generally your children, if they're minors, they're going to receive a lump sum amount of money that then their guardian or their conservator will be able to have control over while they're still minors. But when they turn 18, they would receive that money as a lump sum. Now, I don't know how many 18-year-olds you've met, but I have not met very many who can be trusted with an enormous lump sum of cash upon their 18th birthday. And that's why a trust is nice to set up. You can articulate exactly when you want your minor children to get access to exactly how much money. For example, a really popular strategy is to say that I want my minor child to get a third of their inheritance at age 25, a third at age 30, and a third at age 35. That helps protect your legacy and also protects your children from making some dumb mistakes. A living trust is also really necessary if you have a beneficiary or a loved one who has special needs. And this is really for two reasons. One relates to the issue of minor children, which that in some cases, giving a lump sum to an individual that does have some kind of disability can put them in a tough position if they do not have the capacity or the ability to manage that money well. But there's actually a second and maybe even more important reason why if you do have a member of your family with special needs, it's really critical to set up a trust. And that's because you can actually unintentionally make your loved one ineligible for government benefits if you do not do so. In a lot of cases, whether you're talking about federal or state benefits, Medicaid is an example. If someone with special needs inherits a lot of money, that can put them outside the eligibility range for those benefits they were enjoying, which is generally not the intention of someone who is putting together an estate plan. This can be avoided very simply by setting up what's called a special needs trust that makes money available for that person with special needs, but in a way that they don't have direct control of it, which maintains their eligibility for government programs. Another time that having a living trust goes from a nice thing to a really, really crucial thing is for blended families. We talk to a lot of married couples who had been married previously and who have children from those prior marriages. It's very common. But without a living trust set up, if you're just relying on a will, or if you're just relying even worse with no will at all, what you're risking is that whichever spouse lives the longest, she gets an outright share of the estate, therefore meaning her children from a prior marriage benefit, but the spouse who passes away first might be unintentionally disinheriting their own children. With an estate, you can set up clear instructions to avoid this by making sure that both your spouse is taken care of, the surviving spouse, for the remainder of his or her life, while also making sure that you're retaining part of your estate for your own children. And the last special scenario where having a trust goes from nice to really, really important is if you own real property in multiple states. We already talked about how important it is to avoid the costly, time-intensive probate process. But that probate process becomes even more costly and even more time-intensive if you own property in 2 or more states. Because at that point, you're making your loved ones, your heirs, not only have to file a petition in probate court in the primary state that you live in, you're making them go to 1, 2, 3 other states and file what's called ancillary probate in those states as well. Sometimes it doesn't only mean that they're going to have to pay court costs in multiple states. They might have to hire out-of-state attorneys in multiple states as well, making the probate process, which is already no fun, even worse. Here at Paré Associates, we've been helping families put together smart estate plans for more than 30 years. Give us a call, shoot us an email, contact us, and let us know if you'd like to sit down for a no-obligation, free consultation so that we can put together an affordable and comprehensive estate plan that fits you and your family's needs.